This is a podcast dealing with the key issues considered in the second seminar relating to reformed company law in the UK. As we saw in that class, the question of the reform of company law had been ongoing for some time before the new Labour government coming to power in 1997 began the process that would lead ultimately to the Companies Act 2006. So prior to that government coming into power, there was a recognition that company law in the UK was somewhat outdated, that the foregoing reforms had often been rather piecemeal, and as a consequence, the legislation in place was not always as coherent and up to date as might be desired. Furthermore, there was a sense that some important issues in company law were not readily accessible in legislation, but rather were had been created by case law. In those circumstances, then, the new Labour government launched a process, Modern Company Law for a Competitive Economy, and it was clear that it had a variety of different issues in mind. So clearly it was concerned with that overarching issue of the modification and clarification of company law, but it was also concerned to ensure that it didn't take any steps that would damage the competitiveness of the UK in the global economy. In other words, it appeared not to want to engage in any too radical change in company law such that that might deter investors who had options as to where precisely they would put their capital. We can see that balancing act in the initial letter from the then Secretary of State, Margaret Beckett, laying out the start of the reform process, when, for example, she makes it clear that everything is up for grabs. This is going to be a wide-ranging review and reform process, but then on the other hand says that there won't be change for the sake of change, and the letter proceeds on that basis. In the fullness of time, a steering group is set up with a range of experts, and they are given the task of coming up with proposals for reform, proposals that will inform potential future legislation. What's interesting, or among the interesting things at that point, is the fact that the steering group itself considers that it has to return to some fundamental philosophical questions before it can really proceed further with its work. And among those questions, of course, is that issue of in whose interests must the company be run. And that, of course, we can trace back to the foregoing debate, all the way back to E. Merrick Dodd and Adolf Berle in the 1930s. Now, in seeking to answer that question, the steering group laid out a couple of possible models. One was enlightened shareholder value, the other was pluralism. If we start with that second one, pluralism is simply another way of expressing the idea of a stakeholder model of the company. In other words, a model which is more explicitly aware of and recognizing that a variety of constituencies have a stake in the company. In other words, will benefit when the company is doing well and will suffer when it is not. So we'll come back to that one. Enlightened shareholder value is interesting because the steering group was of the view that this particular version of a kind of stakeholder primacy model essentially reflected the law as it already stood. But it nevertheless acknowledged that even if that were the case, the import of the law was not actually widely recognized and understood by company directors and others. So one of the things that it might then do would be to seek to clarify what this existing model of the company actually meant. And in essence, what enlightened shareholder value implied was that directors would be given the duty to make decisions in the context of the company, in the context of the board, to promote the success of the company for the benefit of the members, that is, the shareholders, whilst having regard to other relevant interests, for example, employees, creditors, suppliers, community, that kind of thing. The pluralist model, of course, would imply perhaps a broader set of duties on the directors, if that were to be the case, or alternatively, a different model of the company altogether, with a variety of different interests perhaps more directly represented in the decision-making or governing bodies of the company. So those were the two models that were set out, and the steering group was essentially looking for feedback from the broader community on their preferences, if you like, in relation to those two models, and indeed was open to the idea that other models could be proposed. Now, as we saw in the class, the steering group then proceeded by way of a number of iterations to develop its thinking in response to the feedback it was receiving, and in the fullness of time abandoned the pluralist model as a potential model for future legislation, and instead favoured enlightened shareholder value. And it abandoned the pluralist model on the basis that it was worried that it might not be optimal or indeed at all convenient or practicable if directors were given more than one constituency to prioritise in their decision making. And furthermore, they were of the view that no one had really been able to come up with what they regarded as a workable model under that heading of pluralism or stakeholder. That being the case, in the fullness of time, the steering group proposed that future legislation would indeed include a codification of directors' duties, very much in the form that it had outlined right at the beginning, and that would then form the basis for reformed company law. The government duly accepted those recommendations, and eventually what we have today as Section 172 was passed into law, which indeed does represent the codification of directors' duties, where the duty is on the director to act in what they consider to be the interests of the company, to promote the success of the company for the benefit of the members, the shareholders, having regard to certain other interests, a non-exhaustive list which mentions employees, suppliers, community, environment, that kind of thing. Now, on one hand, we could regard this as undoubted progress. We now have much greater clarity about what directors' duties imply. On the other hand, I suppose some may be disappointed that more radical change was not considered. And in terms of that second position, that sort of greater disappointment, I suppose one could look at things like the acknowledgement of the steering group at an early stage that in the context of the company, a variety of different stakeholders bore residual risk that could not be contracted away. In other words, that seemed to be a recognition of Williamson's insights in relation to firm-specific investments. Now, that recognition having been made, one might argue, I suppose, that something more thoroughgoing than simply the codification of directors' duties might have been expected. On the other hand, of course, one might say that the steering group's conclusions were entirely consistent with Oliver Williamson's himself, because he, in the end, despite making the observation that residual risk could be borne by a number of different stakeholders, did not depart from the status quo where governance rights lay solely with the shareholders. In any case, it's also important to recognise that it was not simply the codification of directors' duties in the context of Section 172 that represented the fullness of the reforms proposed by the steering group. So, for example, the group was clear that the codification of duties had to be understood as part of an overall package that very importantly included enhanced reporting, enhanced narrative reporting. The idea being that if we were to have reassurance that Section 172 was being implemented meaningfully, then we would need more information about precisely what it was that boards were doing to achieve that objective. And that, of course, gave rise to the rather unfortunate events surrounding the implementation of the transposition of the accounting directive, by which the UK government sought to implement the narrative reporting requirements in advance of the passage into law of the 2006 Act, which would deal with the codification of directors' duties. And as we saw when we looked at the paper by Burns and Patterson, the rather unfortunate intervention of the Treasury rather undid a lot of the good work that had been achieved by the Department of Trade and Industry and the steering group over a number of years. Beyond that, we also need to recognise that another dimension of the reform process was the placing on a statutory footing of the derivative action. At common law, it had always been the case that in the event that directors were perceived to have breached their fiduciary duties, then given the impracticability of expecting the directors themselves then to take action on behalf of the company against themselves, common law recognised a derivative action, in other words, the idea that shareholders could approach the court and seek to derive an action so that they would take action in the name of the company to vindicate the company's rights. That had always been somewhat complex. The precise rules, if you like, had never been very clear. There was a sense that the whole thing was rather too opaque. So placing that on a statutory footing would hopefully make things somewhat more straightforward. Now, as we've seen, it remains the case under the new statutory derivative action that, of course, the court retains a sort of gatekeeper function. Shareholders who seek to derive a right of action cannot simply do so without further ado. They actually have to have the permission of the court to proceed. And then, of course, we're in the position of trying to understand on what basis the court may or may not allow such action to proceed. And we saw in the paper from Joseph Lee that the courts can take different lines in this regard depending on how they understand the position of the shareholders. insofar as the courts understand the company pretty much along the lines of the nexus of contracts model, in other words, understanding that the market is a key determining factor in the equation, then they would be less likely to interfere, as it were. They would assume that shareholders were well able to look after themselves. On the other hand, if we take his alternative position, that of asymmetric paternalism, then the idea would be that the court would be more willing to intervene on the basis that shareholders will always be at a disadvantage vis-à-vis the directors because of asymmetric information. So much then depends on how the courts view the overall situation in terms of whether or not they will be minded to allow derivative actions to go ahead. Generally speaking, the view seems to be that courts are relatively unwilling to interfere unless there appear to be very clear grounds for doing so. The courts are cautious that shareholders may not often be acting as it were to vindicate the rights of the company so much as to try to undo decisions which they themselves perhaps regard as problematical to their own interests. So that's the basic overview of some of the key issues that we see in the Companies Act 2006 on the basis of the steering group's work in the context of the Modern Company Law Review. A couple of other things before we sign off. The first one is the overall question of just how radical the reform could have been given the overall context. And I suppose, as we alluded to briefly at the beginning, there is a sense in some quarters that New Labour was cautious of taking any action that was too radical. It was aware that the business community was itself nervous of the return to power of Labour after the difficulties that party had experienced in government in the 1970s, albeit in a very difficult global situation, and as a consequence did not want to do anything that would perhaps unsettle investors. The second thing before we sign off is the issue of institutional investors. So also included in the Companies Act is the power given to the Secretary of State to make regulations to require institutional investors to make public their voting records in relation to companies in the general meeting. Now, this seems to be a rather obscure power until, of course, one realizes that much in UK company law, and in particular in relation to large companies, particularly large listed companies, much depends on the role that shareholders and in particular institutional investors have to play. We've seen at various points in our discussions on this course that the expectation that institutional investors will play an active role in monitoring and disciplining boards, consistent with underlying economic models such as agency cost theory, things like that. That expectation has often been disappointed. We've seen that institutional investors have other ways of protecting their interests, for example, holding broad, diverse portfolios to hedge risk, which in their eyes may negate the need for detailed monitoring of governance of individual companies. Now, one way in which it appears government, parliament has sought to change that position is indeed in that provision in the 2006 Act. The idea that the Secretary of State could at some future date make regulations that would require the public disclosure of voting records is essentially a way of encouraging institutional investors to make that information public themselves, on the basis that were it left to the government, the precise regulation and the precise requirements may not really be to their liking. So they're being encouraged to act on their own initiative to make those records public. And of course, then the next step is the expectation that institutional investors may well be unwilling or embarrassed to reveal rather inadequate voting records, perhaps a sense that they're not voting at all, or when they are voting, they're not really challenging what boards are doing. And therefore, this is a rather indirect way, if you like, of encouraging greater engagement by institutional investors. So that's another dimension to this reform agenda that is worth bearing in mind. And of course, one that we come back to at other points on the course. So, a quick overview of some of the key issues in the reform process, and also a hint at various points of how they intersect with underlying economic theory, and of course intersect with things like the code-based approach, which we come on to in due course, and indeed other aspects of the course, such as the role of institutional investors and indeed of boards in the financial crisis. Thank you for your attention.